So on the menu today, so I will first kind of try to give a typology and explanation of the diversity of sanctions regimes around the world, but by specifically focusing on some of them, the UN EU regimes, and then the US regime, and lastly the upcoming UK regime. I will focus a little bit on Russia and Iran, but as Michael has already given really interesting details on those regimes as they have been conceived under EU law, I will not take time on that. And as I said, third and fourth topics will be talking specifically about the US and the UK regimes. So, discussing the diversity of sanctions regime, just a little definition, because we talk about sanctions. Some people talk about financial sanctions, economic sanctions, trade sanctions, embargoes, restrictive measures. What do we mean talking about that? So basically, what we call sanctions today are economic, trade, and financial restrictive measures that are adopted from time to time, either by countries and or by or international organizations via laws and regulations. They are adopted in pursuit of specific foreign policy and security objectives, including the fight against terrorism and proliferation, as Michael very well explained. And they are in constant evolution, and they're taking several forms. That would be really a snapshot definition of what sanctions are. As I just said, we call that sanctions, although they don't have a punitive nature, as it has been conferred by the European Court of Justice, among others. But I will not get into those details because I know that one speaker will, either today or tomorrow. But the formal term will be restrictive measures, because the idea is to restrict some individuals or governments from abusing their powers in terms of human rights or other threats. I'll just give a few more on this definition. As you see, we're talking about economic, trade, and financial measures. I will give more details about the kind of measures that have been adopted. They're very diverse, and they're tailored depending on the country or the thematic that is involved. Adopted from time to time and in constant evolution, because as those sanctions or restrictive measures depend on the geopolitical agenda and the evolution of threats on a global level, they do evolve a lot. So one thing that's very complex with sanctions, it is precisely that they're always evolving, and that you have to be careful about the evolution to be sure that you're always complying with them. So that's something very important, and I will just give an example right after that. Let's give that precise example. I just show you a recent resolution that was published by the European Council. It's sanctions on Venezuela that were extended less than a month ago until November 2021, which explains, which proves the constant evolution of those sanctions. If you look at what's written in the text, the Council decided, in the light of the ongoing political, economic, and social and humanitarian crisis in Venezuela, to extend those sanctions because the government has been undermining the rule of law and the respect of human rights. Those sanctions in Venezuela, against Venezuela, are an embargo on arms and on certain equipment, and as well as the listing of 36 individuals where you have to their travel and freeze their assets. And as the Council is saying, these measures are to help encourage democratic shared solutions. Well, the idea basically is to try to force Venezuela, by those sanctions, to adopt a more positive attitude towards its citizens and its population. So here is a perfect example of the diversity of sanctions. And I will now try to give some more examples and typologies of the sanctions that as we know them. So first, in terms of objectives, it is defined by below, sanctions are intended to promoting international peace and security, preventing conflicts, support democracy, the rule of law and human rights, and defending the principles of international law. But sanctions can have other objectives as well. And as Michael just pointed out, you think about the US sanctions that are operated by OFAC, which is the Office of Foreign Assets Control. Well, US sanctions have also as an objective of preventing threats to the national security policy or the US economy. So US sanctions do intend to protect the US economy. And just throwing out one example that was conveyed in the press, if you about those sanctions that the US government, the Trump administration, imposed on Huawei. The US have explained that those sanctions have been adopted of national security because of the Huawei would pose in terms of spying on US citizens and others. But some commentators have argued that those sanctions on Huawei actually maybe more are also intended at preventing Huawei to take too much strength on the 5G global market, which the US has been working a lot to develop as well, and that the US were trying as well to protect their economy in terms of developing 5G by trying to put more burden and restraint Huawei from developing its own 5G network. So you see there are some intricacies here. It's quite interesting, and sanctions can have diverse objectives. In terms of targets, sanctions can target jurisdictions, either whole country or region. We can think about North Korea as a country, or Crimea as part of the Russian sanctions, where imports is entirely banned from an EU law perspective. Sanctions can also target sectors, so within a particular jurisdiction, not prohibit any kind of activity with that jurisdiction, but only activities in some sectors, for instance, oil and gas, financial services, etc. Sanctions can also target sensitive products like arms, so prohibition to trade arms in jurisdictions because the fear that they will use that against their own population. Another example, interesting example, is dual-use goods. So dual-use goods are those items that can be used both for civil and military purposes. Well, it is prohibited to trade and to export dual-use goods in certain jurisdictions, where also the fear is that people use dual-use goods for military purposes against their people. Last but least, we'll be targeting designated listed persons, what the US called SDNs, so specifically designated nationals. These are individuals, companies, groups that are targeted personally, and where you have to freeze their assets and you have to restrict their travel to put some pressure on them and maybe their governments. Talking about those targets in terms of individuals and companies, etc., sanctions can target non-EU governments, can target entities, companies, group or organizations, terrorist organizations such as Al-Qaeda, or specifically individuals. Basically, what you would do as an operator is when you're contracting, like starting a relationship with clients, Michael talking about the example of a bank, you would first screen your prospective clients against a sanctions list to see whether that individual is listed on a particular sanctions list. Speaking of sanctions list, I'm trying to give even more flavors to this. So you do have what we call sanctions lists, which are listings that have been adopted and published by either local or international authorities, and which specified who are the sanctioned persons, who are the sanctioned countries, which are subject to economic, trade, and financial restrictive measures. You have what we call sanctioned persons. These are individual groups and entities that are subject to sanctions and with whom business is prohibited. And in terms of lingo, we also often speak about sanctions jurisdictions. These are the countries or territories where you have either prohibition to conduct business, or where restrictions apply in terms of type of business that can be conducted. That is why I was saying a bit earlier that sanctions are not pure prohibition and punition. It can be restrictive measures whereby you may be able to do a certain type of business, but sometimes subject to being granted an authorization. In terms of diversity of regimes, you can see I've drafted like 3 different circles. Why? Because at the very basis, you see there's the UN Security Council resolution. So as Michael pointed out earlier, the very beginning emergence of sanctions came from the UNSC, first against Al-Qaeda and the Taliban, and then it expanded to other topics other than terrorism and proliferation related. So the UNSC adopted a corpus of sanctions regimes to protect human rights and democracy. Then the EU has been implementing all the UNSC resolutions, so all the UN sanctions that have been adopted by the UN. So basically, when you're complying with EU sanctions, you are, by effect, complying with UN sanctions. However, as you can see, the circle for EU sanctions is broader than the UN one. Why? Because, as Michael pointed out as well, the EU has developed the power to adopt autonomous sanctions, sanctions that can go further than the UN sanctions regime. And we obviously think about Russia. There's no Russian security. Russia member of the UNSC. So the EU has adopted its own corpus of sanctions against Russia further to the annexation of Ukraine. And then you have member states. Member states obviously do have, EU member states do have to comply with EU regulations. But here as well, the circle for the member states regimes, sanctions regimes, is broader than the EU one, because member states also have the possibility, if they do have adopted specific legislation to that end, to developing their autonomous regimes in a way that they will first comply with the UN and EU sanctions regimes, but they will also add a layer and add their specific sanctions regimes that their citizens will need to comply with. So you see the diversity and of this more complex. Why? Because here we're only talking about EU sanctions, but you might be an EU person and have also to comply with third country sanctions. And this is the purpose of the next slide. Here you see it better, I think. And obviously I've taken the US sanctions as an example. You see that the circle is not exactly overlapping the EU sanctions. It is overlapping the UN sanctions. Why? Because obviously the US also comply with the UN sanctions regimes. However, the US has a broad power to develop its own sanctions regimes. As Michael said, it has been very keen to doing it. The US are quite aggressive and proactive in terms of sanctions development. It has been the case under the Trump administration, as you and therefore, US sanctions to some extent overlap with EU regulations. However, because they're working hand in hand in some aspects. However, in the last years, we have seen more and more divergence between US sanctions and EU sanctions, specifically in of Iranian sanctions. I will talk a little bit about in a moment, and then I will leave the floor to Basile San, who this afternoon will explain the difficulties of complying with both EU and Iranian sanctions, EU and US sanctions against Iran. So as EU person, you may have to try to comply with all those different sanctions regimes, which can prove quite difficult in some instances. So from a more legal perspective, in terms of articulation of diversity of sanctions regimes, as Michael already said, you have UN resolution and EU CSFP decisions, which are binding standards for member states, but not directly applicable on natural illegal persons. Then you have EU regulations, which are binding on EU nationals or persons located or doing business in the EU, and which are directly applicable in EU member states. You have EU member state legislation applicable to national citizens and residents. And one thing that is important to note is that regulations and legislations on sanctions do not have retroactive application, which is very important, obviously, because they're evolving all the time. I'm sorry if I'm going quite fast, but I've been asked to talk about quite a complex and extensive topic, and I'm trying to cover it in within time that has been allocated to me. So here, in terms of diversity of sanctions and focusing on the EU regime, I've put a map of the EU sanctions that apply country per country. So all the reddish countries are those where there is a EU sanctions program against them, and I've given a bit more details on two very important sanctions regime that we talk about all the time, is the Iranian sanctions regime and the Russian sanctions regime, which includes sanctions against Crimea. If I try to do a little mapping of EU sanction sectors by jurisdictions, and again, this is to give you more flavor and to be more concrete about the different kind of sanctions that apply at the EU level. I'm not going to detail everything here, but you will have the time as you have the slides to read them carefully. Currently, there's over 40 different EU sanctions regimes in this. They're mostly mandated by the UN Security Council resolutions. Others have been adopted autonomously by the EU, as I was pointing out just a few minutes ago. So, for instance, you see that in terms of arms trade, there are sanctions against a number of countries such as Belarus, China, Congo, Lebanon, Myanmar, etc., etc. Dual-use goods, which I was talking about early on, it's prohibited to trade and to export dual-use goods to Iran, Myanmar, North Korea, and Russia. Other examples, you see also sanctions in terms of trade, specials, metals, stones, etc. In terms of agricultural products, I think that Michael has already explained quite a bit the way those sanctions are crafted depending on the jurisdiction and the geopolitical situation we're talking of. Maybe one last comment I will do about the mapping of sanctioned sectors is the asset freeze and prohibition to make funds available. So basically, in that part, you have the countries against which sanctions have been adopted, and which includes a list of persons that must have their asset frozen and or must have their travel restricted. You have a lot of countries, but one thing that is important, I was just about the fact of operators of screening their clients and or prospective clients. It's not because you have a client that operates from one of those countries that this client is subject to sanctions or is of higher risk. On the other hand, it's not because you have a client from one on a non-listed country that there's no risk that they are listed persons. I'm from Belgium. As you may see, Belgium is not in that list because there's no sanction programs against Belgium. However, indeed, Belgian citizens which have been listed on a sanctions person list and who must have their asset frozen. And we specifically think about those persons who are suspected to be linked to terrorist organizations. So sanctioned persons can have other citizenship. So if you're a private operator, if you're thinking about screening clients to be sure that they're not subject to sanctions, do not really care about that list, just automatically screen any client you have, whatever their citizenship. That was more from a business perspective. Reach of sanctions. So in a nutshell, sanctions apply to all persons. That's different from compliance with AML legislations, for instance, whereby only specific economic operators have to put into compliance controls into place. Here, every single citizen or EU person has to comply with EU sanctions. Those sanctions can be prohibition or restrictions to conduct business. They're not limited to trade exports, because often we think about sanctions as embargoes, which is about trade. No, sanctions are broader than that, as I've just showed you with the previous slides. It's not limited to sensitive countries or sectors. As you can see, there are sanctions against Lebanon, China, and other countries you would not think about specifically, contrary to North Korea, Iran, Syria, and Russia. And they're also directed to terrorism proliferation, obviously. The risk or rule-based approach is a very interesting question in terms of compliance. I will not dive into this right now, because my point is to give a broader overview of the reach and diversity of sanctions. So, just to remind you as well, sanctions enforcement, where you're not complying with sanctions that have been implemented, adopted at EU or national level, you are subject to criminal penalties, imprisonment, fines, confiscation, and/or administrative sanctions as a result of an investigation and enforcement by national authorities. So even EU sanctions, where they're not complied with, you don't have a European body that's going to investigate you and impose sanctions on you. It is the national authorities that will have to investigate and apply the sanctions they have adopted at national level. Non-complying with sanctions can lead you to that kind of criminal penalties or administrative sanctions, but can also have other effects, such as the risk of reputational damage, because obviously if you're publicly known for have violated sanctions, that will have an effect on your business and also on your contracts and operations, because in most contracts now you have a sanctions clause whereby it is stated that if you're not complying with sanctions, the contract will be void, terminated at your fault, and you can lose financing from banks, you can lose insurance, and you can have difficulties to be involved in M&A operations in the future. So violating sanctions can have really drastic effects, so it's really important to comply with them. As I was saying, the second part of my speech is directed to a brief overview of Russian and Iranian sanctions. I will be quite brief because Mike already spoke about that. Russia, an EU perspective, sanctions were taken in response to war in eastern Ukraine and annexation of Crimea. But from a more specific perspective, you can see here the kind of sanctions that have been adopted against Russia. Again, I will not dive into that. I leave you to reading the slides when I have to. From a US perspective, what is interesting is that sanctions against Russia have been evolving quite a lot in the recent years, and they're increasingly out of sync with sanctions, where at the beginning they were mostly the same. Over the years, we have been observing and out of sync with the EU, which is really important because it speaks out to the diversity of sanctions and the difficulty to cope with all the different regimes at the same time. In terms of sanctions against Iran, there's a variety of sanctions which were adopted since 2006 and then 10 at EU level, I think. Remember that in 2015, the JCPOA was adopted by the 5 permanent members of the UNSC plus 1 member, the EU and Iran, with a view to having Iran committed to stopping its nuclear proliferation, and in exchange of that, the members or the parties to the JCPOA decided to lift up the sanctions that were applied to Iran, and things were kind of smoothly. Here's the different sanctions that apply at EU level in terms of Iranian sanctions. Things were going quite smoothly, as I was saying. However, as you know, in 2018, President Trump decided to withdraw from the JCPOA and to recast a lot of new sanctions against Iran, so that today we really have a different scope of sanctions when we compare the EU sanctions and the US sanctions against Iran, which leads to a lot of issues. I will speak a little bit about that later on, and as I was saying, Basil San this afternoon will dive into that subject way more than I do. So again, sorry for that brief section on Iranian and Russian sanctions, but as I was saying, Michael already talked about that, and due to the time I've been allocated, I will now try to focus for the last 15 minutes of my talk on US sanctions and the new post-Brexit UK sanctions. So in terms of US sanctions, you have 3 kinds of sanctions at US level. Sorry, there are export controls, which apply to items, which you will think about as embargoes. You have primary sanctions, which apply to US persons, and you have secondary sanctions, which apply to non-US persons. And what is important to note, and that's why I've been asked to talk about that today, is that all these 3 categories of sanctions, US sanctions, can also apply to an EU person. That's important because a lot of persons in the EU are not aware that US sanctions can kick in, apply to them, and that they can be subject, according to US law, to US enforcement and sanctions violating their own sanctions regimes. So export controls as a first. So export controls, so your US person or not is relevant. Basically, export controls are designated items that are subject to export controls, meaning that are subject to obtaining a license from the US Department of Commerce with a view to exporting or re-exporting that item, because the item is considered as sensitive. The more sensitive the items, the more important the controls. Violating export controls can lead to imprisonment, fines, exclusion, prohibition to export, etc. So basically, you might be a European operator that is concepting and trading goods that have US components. So if you want to export that good that has more than 10% US components to a third country, you need to have a license from the US Department of Commerce if you're subject to sanctions in the US. And that's how, as a non-US person, you might be subject to the first regime of US sanctions on export controls. A second regime is primary sanction. That's the main regime that people know about. So basically, it's sanctions that apply to US persons and to transactions in the US. Sanctions against North Korea, against Iran, against the whole thematic and countries that have been developed by the US. So how can a non-US entity or person may be exposed to primary sanctions in the US? Well, there is a relation with the US. Either that the transactions is conducted from, through, or with the US, or if you're involving a US person in the transaction. So the best example to give you is, think about your Luxembourg operator dealing with Iran. If you're trading in dollars when doing that deal, well, you are subject to US primary sanctions. Why? Because just the fact that you're dealing with US dollars means that that transaction has to be cleared through the US financial system, and therefore that you have conducted the operation through the US. And so the US can sanction you directly for violating their own sanctions regime based on the primary sanctions regime. Third, and more confusing to some extent, is secondary sanctions, which is a bit less known than the other two regimes. Secondary sanctions actually apply to non-US persons. It is the fact of being a non-US person having no ties with the US, but conduct business that doesn't suit US sanctions regime. So basically what the US will do is tell you, Italian operator, you have been dealing with that specific Iranian or Russian company, which you know is an SDN under the US regime. We urge you not to do business with that company anymore because that doesn't comply with US sanctions. And if you decide not to listen to what the US government is asking you to do, the US government can put you on their secondary sanctions list. So they will list you specifically, that Italian or Spanish company, as a secondary sanctions SDN, meaning this is a non-US company that has no ties with the US, but we don't accept that they're not complying with US sanctions, thereby we're listing them as a secondary sanctions SDN, and thereby that person can never do business in the US. That's a way as well to sanction non-US person and to make them comply with US sanctions. Secondary sanctions are known, have been reinstated in quite broad extent within the scope of Iranian sanctions, and they're also used now by the US within the scope of Russian sanctions. And it appears that secondary sanctions will be used more and more in the future by the US administration, depending on the direction, the policy direction of the US administration. Obviously, it was the case under President Trump, with the view to try forcing the world complying with US sanctions. Last thing I want to say, I've been saying that there's a big divergence now in terms of sanctions against Iran between the Russian and the US and the EU regimes. And that leads to some problems because, as I told you, President Trump decided to withdraw from the JCPOA and to reinstate very far-reaching sanctions against Iran, which broke the balance that had been reached with Iran through the JCPOA. So the EU was quite sensitive about that issue and didn't take it very well from President Trump, and therefore adapted an old statute which is called the EU blocking statute. It's a EU regulation which prohibits EU persons to comply with lists that go beyond what is established under EU sanctions. And meaning that EU person cannot comply with those US sanctions against Iran if they go further than the EU sanctions, unless prior authorization is given by the European Commission. So basically, you now have a conflict of US-EU law, whereby you have EU person that want to do some kind of dealing with Iran. It's authorized under EU law, but it's prohibited under US law. And those persons are subject to both laws. And basically, the US says, well, if you do comply, if you do that business with Iran, we will sanction you. And the EU says, well, you cannot comply with the US sanctions. If you do, you will be sanctioned under EU law. So EU persons are placed between a rock and a hard place. It's a very difficult situation. And I'll leave that to Basil San this afternoon. But again, that is to explain the complexity we live in today in terms of sanctions compliance. One thing that is important for me is if you're more confused after this presentation than you were before, that means that I have succeeded in my challenge of explaining the diversity and complexity of the regime, because it's always a hard thing to cope with. So lastly, and these will be the last 5 minutes of my presentation, is the post-Brexit UK sanctions regime. Because you know that Brexit is on its way. The end of the transition period is coming. Before Brexit, obviously, UK was a EU member, and UK was implementing EU sanctions regimes as all other member states. The situation is a bit different because UK is withdrawing from the EU, and the question is, what are they going to do? How will the post-Brexit UK sanctions regime look like? So basically, during the Brexit transition period, EU sanctions continue to apply. This means that until the 31st of December of this year, 11 p.m., EU sanctions continue to apply in the UK. Which also means, if you think about the beginning of my presentation, that UN sanctions continue to be implemented in the UK through EU law during this time. So until the end of the year, things are as they were before. EU law applies, EU sanctions apply in the UK. However, how will things be after that? So knowing that, during the Brexit transition period, the UK has decided to implement its own and autonomous sanctions regime with a view to being able to comply with its international obligations, such as signing with UN sanctions, and being able, after Brexit, to adopt to new sanctions or to lift some sanctions, depending on the international evolution. So in order to do that, the UK has adopted a self-standing global human rights sanctions regime, which is already in force. It did so in 2018 through the Sanctions and Anti-Money Laundering Act 2018, which I will call, for the purpose of this presentation, the Sanctions Act. So through that self-standing new legislation, the UK is now able to adopt self-standing legislation, secondary legislation through regulations that will help the UK comply with its international obligations in terms of sanctions regimes. So basically, the UK government already publishes the UK sanctions list, which provides details on those designated under regulations, so secondary law made under Sanctions Act. For instance, in July of this year, the UK adopted the Global Human Rights Sanctions Regulation 2020. It's very interesting because it appeals to what Michael was saying earlier, is that the European Union is right now finalizing the adoption as well of a human rights autonomous sanctions regime, which is a bit like, if you think the Magnitsky Act of the US, which actually aimed at being able to targeting specific individuals, irrespective of their nationality, which were not complying with human rights. And that's also what the Global Human Rights Sanctions Regulations 2020 is about. So as I was saying, there's now a self-standing act in the UK, and the UK has to adopt secondary legislation, so regulations, in a way so as to adapting its sanctions regime according to the evolution. So, for instance, and that's the first part, stemming from the Sanctions Act, the UK has been adopting in 2019 and 2020 a number of regulations that will come into force at the end of the transition period, so as from 1st January of next year, and that will replace EU sanctions law. So you have a number of regulations, if you look them up on the internet, on the UK government website, which are basically, and their name is either the thematic, so cybercrime, terrorism, etc., or the country name, for instance, Russia, and then sanctions, EU exit regulations, either 2019 or 2020. And those regulations actually implement the current EU sanctions regime within the UK, but with some divergences in some respects. So we can already witness to a little extent that the new UK regime will be mostly similar to the EU regime, but with some divergences already. And you also have some sanctions EU exits, miscellaneous amendments regulations of 2020. So that's how the framework is looking like during this transition period, and that is preparing the end of the transition period, meaning as from 1st January of next year. So basically as from next January, the Sanctions Act will be applicable, is already applicable, but will be the self-standing legislation to lift sanctions or impose new sanctions in accordance with international law. But as an interesting thing as well is that the Sanctions Act also gives the UK powers to introduce other new sanctions regimes. So it really gives the UK the power to introduce autonomous sanctions regime that do not fit with the UN or other international EU regimes. So it goes further than strictly necessary to achieve post-Brexit compliance. And on the second hand, as I was saying, there will be the application on thematic country-specific regulations replacing EU law. This is separate standalone sanction regimes, which will need to be carefully reviewed for compliance purposes because they will diverge from the EU regime in several respects. The last comment I want to make is that, so we're coming to a new era in the UK. The UK government has indicated that post-Brexit, it will continue to work closely with the EU and with other international partners on sanctions. So the question that now is being asked is whether the UK will continue sticking with EU sanctions and developing sanctions regime in parallel, which seems to be the way, the indication they have given. Although, as I was saying, the new legislation, sanctions UK legislation, already diverge in a way from some specificities from the EU regime. And on the other hand, some commentators are wondering whether the UK will take this opportunity to get closer to the US sanctions regime. So we don't really know right now what will be the policy orientation of the UK in terms of sanctions regime, but we have to be aware, and I think that's the message I want to give to in terms of post-Brexit UK sanctions, is we might see another divergence, another shift in sanctions policy, which will make it even harder in the next month or years to comply with all the coexisting sanctions regime at EU and broader and international level. Having said that, I've arrived at the end of my time. I will just conclude as such. Thank you for your attention. I know it was a lot to digest in only 45 minutes. I hope of interest to you, and please don't hesitate to ask questions.